Your tenant hasn't paid attention to warning letters. Neighbours are complaining. The police have attended incidents. The local authority has received reports. The behaviour is affecting people living around the property. A council eventually managed to evict a tenant in Stoke-on-Trent and board up the property following persistent antisocial behaviour. But here's the question. If that tenant lived in a privately rented property rather than a council property, could the landlord achieve the same outcome? Because under the Renters' Rights Act, the no-fault Section 21 eviction route has been abolished. As a result, landlords dealing with antisocial behaviour face greater responsibilities when gathering evidence and demonstrating to the court that the tenant's conduct justifies possession. And that's exactly why this case is worth exploring. In May 2026, Stoke-on-Trent City Council secured possession of a property in the Golden Hill area following a prolonged pattern of antisocial behaviour linked to a tenant. The case attracted attention because of the outcome, and because secure council tenancies have strong legal protections. Possession is possible, but it is rarely straightforward. Contrary to popular belief, a council cannot simply decide that a tenant has become a nuisance and remove them. The burden of proof is significant, and antisocial behaviour cases often involve months, sometimes years, of investigation before they reach a courtroom. According to the council, neighbouring residents had experienced persistent antisocial behaviour over a prolonged period. Complaints were received, incidents were recorded, and evidence was gathered over time. This wasn't a case that emerged overnight. Like many antisocial behaviour investigations, it was built piece by piece through incident reports, witness accounts, investigations, and enforcement activity. Local authorities frequently spend months gathering evidence in serious antisocial behaviour cases. They document incidents, work with partner agencies, issue warnings, and attempt interventions before seeking possession through the courts. The reason is simple. Courts require evidence. Neighbour disputes, nuisance complaints, and allegations on their own are rarely enough. A judge needs to see a clear pattern of behaviour supported by evidence that can withstand legal scrutiny. In the Stoke-on-Trent case, the decisive factor was a criminal conviction linked to the tenant's conduct. That conviction fundamentally changed the legal position. Once the council had both the wider evidence trail and a qualifying conviction, it was able to demonstrate that the legal threshold for possession had been met. The court granted possession, the tenancy was terminated, and the property was subsequently boarded up. For the neighbouring residents, that marked the end of a lengthy process. For landlords, however, it raises an important question. What happens if exactly the same situation occurs in the private rented sector? Before we go any further, it's worth making one important distinction. As this was a council tenancy, Stoke-on-Trent City Council would have relied on the possession grounds available to local authorities under the Housing Act 1985. The purpose of this video isn't to analyse the council's legal case. Instead, we're using the facts of the case to explore how a private landlord might deal with similar antisocial behaviour under the post-Section 21 possession framework, including Grounds 7A and 14 of the Housing Act 1988. Prior to the Renters' Rights Act, some landlords facing persistent nuisance behaviour may ultimately have relied upon a Section 21 notice. Whether people agreed with Section 21 or not, it existed as a route that did not require the landlord to prove antisocial behaviour to the court. That route is no longer available. Today, landlords dealing with serious antisocial behaviour must rely upon specific possession grounds and evidence to support them. In a case like the one seen in Stoke-on-Trent, the most important ground may be Ground 7A. Ground 7A is a mandatory ground for possession. Mandatory means that if the landlord proves the ground applies, the court must grant possession. The judge does not have discretion to decide that possession should be refused if the legal requirements have been satisfied. However, many landlords misunderstand Ground 7A. It cannot be used simply because neighbours have complained or because the landlord believes antisocial behaviour has occurred. Specific legal thresholds must be met. One of those thresholds is a qualifying criminal conviction. The conviction must relate to conduct committed in the property, in the locality of the property, or against someone with a connection to the property such as a neighbour or the landlord. Ground 7A can also be triggered if a tenant breaches a civil injunction granted under antisocial behaviour legislation. It may apply where a criminal behaviour order has been breached. It can also be activated where a court has granted a closure order lasting more than 48 hours because of persistent antisocial behaviour, criminal activity, or serious nuisance connected to the property. There are also circumstances involving statutory noise nuisance where enforcement action has been breached and legal thresholds have been satisfied. These are not minor complaints or isolated incidents. The legislation deliberately sets a high threshold because Ground 7A carries serious consequences. If a landlord wishes to rely on Ground 7A, they must serve the prescribed notice using Form 3A. This is the official government notice seeking possession of a property let under an assured tenancy. The landlord must clearly identify Ground 7A within the notice and explain exactly why they believe the ground applies. That means setting out the relevant conviction, order, or qualifying event and connecting it directly to the legal requirements of the ground. Unlike many possession grounds, there is no minimum notice period before court proceedings can begin. A landlord can apply to court immediately after serving the notice. However, while proceedings may begin straight away, the court cannot make a possession order until at least 14 days have passed from the date the notice was served. If the landlord can prove that Ground 7A applies, possession becomes significantly more straightforward because the court is dealing with a mandatory ground. The challenge is that many antisocial behaviour cases never reach that point. Many landlords are dealing with nuisance, intimidation, noise complaints, or disruptive behaviour long before a conviction has been secured. That is where Ground 14, nuisance and annoyance, becomes important. Ground 14 is the discretionary antisocial behaviour ground. Unlike Ground 7A, the court is not required to grant possession. The landlord must provide evidence that proves the behaviour occurred and that possession is a reasonable and proportionate outcome based on the evidence. This is often where cases become more difficult. Tenants may dispute allegations. Witnesses may become reluctant to attend court. Complaints may be inconsistent. Mitigating circumstances may be raised. As a result, evidence becomes absolutely critical. Without evidence, a landlord has concerns. With evidence, a landlord has a case. This is one of the biggest lessons from the Stoke-on-Trent case. The council did not succeed because it was a council. It succeeded because it had dedicated housing management and neighbourhood teams, an in-house legal service, and the financial resources to investigate, prepare, and pursue a complex possession case. Many private landlords simply do not have access to that level of organisational support or funding, even where the evidence is equally compelling. Private landlords facing similar circumstances should focus on building that evidence from the earlier stages. One of the simplest but most effective tools is the incident diary sheet. Neighbours should be encouraged to record the exact date, time, duration, and nature of every incident. Importantly, the effect the incident had on them, not vague descriptions, specific facts, what happened when it happened and who witnessed it. Those records help establish a chronology. Landlords should also encourage neighbours to formally report incidents to the relevant agencies. Every report made to the police should generate an incident reference number. Every complaint made to the local authority's antisocial behaviour team creates another independent record. The more independent evidence that exists, the stronger the overall case becomes. Digital evidence can also be important. Time-stamped CCTV footage, video doorbell recordings, photographs of damage, recordings captured through recognised noise reporting systems, and other forms of objective evidence may all assist. Professional witnesses can provide additional weight. Council officers, police community support officers, environmental health officers, and other professionals may be able to provide statements based on what they have personally witnessed. This can be particularly important where neighbours are fearful about giving evidence themselves. Landlords should also maintain their own records. Copies of warning letters, tenancy breach correspondence, emails, complaint logs, and records of visits should all be retained. Taken individually, these documents may seem insignificant. Taken together, they can create a compelling picture of ongoing behaviour. Where a criminal conviction has been secured, landlords should obtain the official memorandum of conviction from the court. That document can become one of the most important pieces of evidence when relying on Ground 7A because it provides formal proof that the qualifying threshold has been met. Another important lesson is that landlords should not try to deal with serious antisocial behaviour in isolation. Involving the local authority can be crucial. If the council investigates and ultimately secures a closure order because of ongoing antisocial behaviour or criminal activity, that closure order may itself trigger Ground 7A. In other words, council enforcement action may create a mandatory possession route that was not previously available. The Stoke-on-Trent case demonstrates something that is often overlooked in housing debates. The decisive factor was not simply that antisocial behaviour occurred. The decisive factor was that evidence had been collated, legal thresholds were met, and the court was satisfied that possession was justified. For private landlords operating under the Renters' Rights Act, that lesson is important. The conversation is no longer simply about notices. It is about evidence. Good referencing and tenant checks remain important, but they cannot predict every future circumstance. Tenancies evolve over time, and people's circumstances, household dynamics, and behaviour can change. With Section 21 abolished, landlords are now more likely to find themselves navigating those situations through evidence, case management, and the courts, rather than relying on a no-fault route to possession.